Good morning. Good morning. Ladies and gentlemen, please welcome Churchill Club CEO, Karen Tucker.
Good morning. Good morning, everybody. My name is Karen Tucker. I'm the CEO and a board member of the Churchill Club. Welcome to this morning's event, Innovation and Change, a New Normal for the Legal Industry. And there is a question mark at the end of that title, and we'll let you decide after listening to the discussion this morning where that stands. We have a great group of speakers to address the topic. Aric Press of the American Lawyer has come into town for this. We appreciate that, Aric. Welcome. As has, in fact, Bill Deckelman, who arrived from Virginia to join us for the discussion. We also have Mark Chandler from Cisco, and of course, Paul Lippe from Legal OnRamp. Thank you all, gentlemen, very much for being here. I would also like to acknowledge and thank our program sponsors. These companies have been outstanding to work with, and I certainly do encourage you to get to know them. Our lead sponsor is Applied Discovery. Let's thank Applied Discovery. And our supporting sponsors are CT Time Metrics and Vintage Filings. Thank you all for making this program possible. Quickly, a few other Churchill Club announcements. Our next program will be Monday, March 22nd, and it's a program called Feet Speak Louder Than Words with a preeminent expert about body language in business. And this is a network-in program where we have additional networking time after the program so that you can put to use what you learned or find out what you missed. If you are not a member, we certainly do encourage you to consider joining us, and you can always find information about our options for that at churchillclub.org. My last announcement, if you are tweeting today, please do use #ChurchillClub. Now let me turn the program over to our moderator, Paul Lippe. Paul is an entrepreneur. He is presently the founder and CEO of Legal OnRamp. He was with Synopsys for many years in the 90s, a period of high growth for the company on that exhilarating and difficult rise to getting to $1 billion. I think when you left it was 800 million or so, Paul. He wore many hats there, including SVP, General Counsel, and he also ran business development and corporate marketing. He became CEO of Stanford Scholar, which was a medical digital library and e-learning company prior to going on to found Legal OnRamp. And he certainly has a wealth of experience and a passion for innovation and change. I know that he will lead a great discussion this morning. So please do join me in welcoming Paul.
So I took a moment to look at my iPhone while I was being introduced, and Mark was worried I was checking my email. But in fact, because the iPhone is a multi-purpose device, I was looking both at my remarks and the thing I was going to reference. So for me, this is a really noteworthy and enjoyable experience. I appreciate everybody coming out. When I first moved to Silicon Valley, which is almost 17 years ago, hard to believe, one of the first things I did was to come to a Churchill Club event. And I've always been really impressed with the spirit of the Churchill Club and kind of the commitment to thinking ahead. I actually just reread a Churchill biography the other day by Paul Johnson. I'm sure many of you have read it. And what's so impressive about Churchill is kind of the juxtaposition of the old and the new. So, for example, in World War I, Churchill was a proponent of the tank to break up trench warfare on the Western Front, and was a great innovator throughout his career, but by the same token, was a great, some might say, excessive traditionalist in many respects. So that ability to balance kind of the innovative and the best of the old is I think, a characteristic of Churchill. It's a characteristic of the Churchill Club, and I think hopefully can be a characteristic for lawyers. So we've got a fantastic panel today, and I want to just briefly kind of set the stage for them. It's genuinely the case that you have the world's top experts in this topic, and I think not just in the panel, but actually in the audience as well. And I'll try to do a few shout-outs to some of those folks as we go on. What I want to talk about is kind of what's normal and how normal changes. About probably half the people in the room are lawyers and half are non-lawyers, so I think folks will hopefully resonate with this. But the way lawyers have, I'll call it traditionally, or maybe even recently, thought about normal is a little bit at odds with the way the rest of the world thinks about normal these days. So how do lawyers think? Lawyers think first and foremost more is better. More lawyers, more documents, more analysis, more research. Lawyers have lived in a world where prices have always gone up. You know, every year you get, as Mark has talked about, the rate increase letter. Lawyers have lived in a world where nothing is measurable. The bogeyman for lawyers, at least for a period, was my not so erstwhile law school classmate, Eliot Spitzer. You know, do this or Eliot Spitzer will come take you in the night. If you ask lawyers why they do things in a certain way, they say, well, that's how we've always done it. And there was a great quote from a newly named managing partner of Cravath a couple years ago. When asked if he planned any change, he said, well, the phrase, if it ain't broke, don't fix it, comes to mind. Meaning, why would we innovate? What we have is working. So that has come to be, for many, if not most lawyers, the definition of normal in law. Now, here in Silicon Valley, here in the world that I think is not unique to Silicon Valley, but in fact the predominant world, a world of global competition and ongoing innovation, most people kind of look at that and scratch their head and say, is that really the way it is? Is that a necessary condition to law? And there's probably 30 people in this room who've asked me that question in the last couple of years. And so if you look at how the enterprise treats normal, it's different. So in the enterprise, better is better. Activity per se is not a virtue. Prices generally go down. Certainly anything fueled by technology, by semiconductor price performance has gone down. Information costs go down. Music costs, transportation costs even have generally gone down. Everything is expected to be measured. And the notion that a general counsel of a modern company can come into an executive staff meeting and say, well, we can't measure our stuff like everyone else does, people kind of scratch their heads. The modern enterprise doesn't, thank God, fear Eliot Spitzer, but it does fear emergent competitors, largely in China, but elsewhere, onshore and offshore. Folks are always asking the question, how can we do better? The answer, this is the way we've always done it, is a express ticket to a severance package. And in the great quote from John Doerr, which I tried to find but couldn't find on Google, he quotes Bill Joy as saying, you know, when you get up in the morning, just remember that somewhere there's a 26-year-old out inventing something that's going to destroy your business. So the notion that there's ongoing innovation, that innovation leads to disruption, and you need to be prepared for that, that's kind of at the core of the modern enterprise. So how is that going to sort itself out in the world of law? Is that going to be a 20-year transition? Is that going to be a never transition? That's the subject for today. The one thing I would suggest to you is that the way lawyers think about how change will happen is perhaps wrong. The model that we have as lawyers is kind of, you know, the miracle in Philadelphia, the Constitutional Convention, all the stakeholders come together and discuss stuff. And that's the default way that lawyers think about how change will happen in the law. But in fact, kind of the Silicon Valley model, the Jeff Moore technology adoption life cycle, or what Malcolm Gladwell kind of popularized as the tipping point, oops, sorry, went one too far, or did we? Yeah, is much more of an organic notion of change. And that individuals will pick things, and those things that they pick will be embraced by others, and that will set the pattern for change. And then eventually the change will happen without any formal decision about how that change would happen. So fortunately for us, we have the fellow who I think is probably the leader in the country, in the world, in terms of thinking about how the legal function will be run in the modern global enterprise, Mark Chandler. And Mark is going to open up by sharing with us some of the innovations and cool things that Cisco's doing. And let me get your slides for you, my friend.
Okay, let's skip the slides. We got enough slides in the world, I think, so we don't need more slides. You know, I think Paul has set the stage very well, and I have a tendency to expand my intellectual horizons by agreeing to give talks on subjects I don't know anything about, and then trying to learn about them. And I was on a panel about standards in antitrust law at a global competition conference in Europe about 6 months ago, and I said, you know, I'm not sure what I have to add because you're all experts, and I just am this person out, you know, working in the field and with sub-analytical observations about what the world is like. So you can take this and interpret it and decide how wrong I am. So I'm a little shy when Paul says I'm an expert on this because I'm not sure I'm an expert as much as someone who just has to live day to day and run a legal department. And so I want to just share a few observations about where I think the world is heading from that perspective. And I think Bill and I were nodding at each other as you were making some of your comments. So we live in the same world, and you might get a different perception based on the nature of our companies. The first thing that really characterizes the world I live in is that I get measured the way every other department of the company does, and Paul alluded to this. I have to have a metric that shows what I'm delivering to the company and what it costs to deliver it. And so the what I deliver isn't that different from what General Counsel have been responsible for delivering for the last 50 years since the rise of the large corporation in the United States. And that is, I have to be able to show that our deals are getting done, first and foremost. The most important thing we can do as a legal department, I think, is be part of making Cisco better than our competitors at designing, building, and selling products. That's competitive differentiation. It's why people want to buy our products. It's why people want to buy our stock. It's how we get measured and create value for all of our stakeholders, for employees, for suppliers, for customers, and for all of us, shareholders as well. And I have to also make sure that the things that are threats to the company get managed, that if there is accusations against the company, that we defend those properly. If there are rights of ours that are being trampled upon, that we have the ability to vindicate those rights and do it efficiently. And that is a little bit more difficult to measure, but we can certainly look at our peers and see what we're spending on litigation, what we're spending in terms of settlements and so forth. And third, we have to be very concerned about compliance. And that is meaning that we fulfill our obligations to the community, whether it's in our accounting implementation and ensuring transparency of our results through Sarbanes-Oxley compliance, whether it's through respecting the marketplace through our competition law compliance, whether we're respecting intellectual property rights of third parties. So those are really the three buckets of activity that I have to work in: competitive differentiation, defending against threats, and ensuring compliance. How do I measure whether I'm doing that efficiently, though, what it costs to get there? And the tool I use, and that I'm being driven to use all the time, is what proportion of the company's revenue is spent on the legal function. Face it, I'm overhead. I mean, if you could do away with the entire legal department and simply have more engineers designing products and more good people out explaining to customers how they work and why they will make customers' lives better, that would be better for the company. So I have to figure out, how do I bring that down every year? So my challenge is every year to make sure that there's a smaller draw of the legal function on the corporate resources than there was the year before, percentage-wise. Obviously, as the company grows, that's easier. In the last couple of years, it's been harder because the growth has been slower, and that then puts cost constraints on me. There are some things I can't control. I'm not going to manage my litigation expense so I have a better legal number by settling unmeritorious cases. And I have a management that understands that, so I can explain some of it, but ultimately, in the long run, I need to be able to show steady improvements. Now, that then leads me to, having described the world I live in, leads me to talk for a second about what is the nature of the tools that I have available to solve those problems. Every knowledge-based industry in the world is being transformed by information technology. How do we get information? How do we use information? How do we transmit information? And it's really a fundamental characteristic of the modern world. It's extremely disruptive. I think anyone who's read Clay Christensen's books understands how that cycle works. And there are historical reasons, however, why the legal community has been a little bit slower to take advantage of the information management opportunities that are out there, slower than other industries have in transforming themselves. And I don't think that there's anybody in the legal world who would say, gee, yeah, we should have been going the way of the newspapers, the last 20 years. That would be a good thing for our industry. And some of the historical factors that I think are driving that are worth noting. One is, frankly, in inborn conservatism to the profession built of relationships. A lot of general counsel come out of law firms, are used to the law firm traditional model, like that model, aren't going to change it very much. Second is the history of professionalism, which is a positive in the legal world in the sense of what constitutes doing quality work, the individual engagement in doing the work, the individual engagement with the client, and a tendency to not trust more automated solutions or self-service solutions that give people access to information. But obviously we're seeing a lot of that get eroded. Everything from TurboTax to Willmaker and other tools that are doing a piece of what's really legal counseling. We have the role of state bar associations and other professional regulatory associations which will view alternative ways of providing legal services as not meeting professional standards, but also I think traditional analysis would say that it also is a reflection of trying to suppress competition. And a tendency in law firms, because the model has been built around a very simple way to measure value, which is how much time was put in, to not finding efficient ways to look at what are the inputs to finding a legal solution. A law firm, in my experience, typically looks at the principal input that goes into providing value to client being the time of the lawyer doing the work. And the value of other inputs, perhaps because it's been hard to monetize them, are denigrated. So that's the challenge I have as a general counsel, is to provide those services efficiently, dealing largely with the legal world that for a variety of reasons has not taken advantage of the information technology revolution. The question is, what's the new normal? And I think what's happening is a period of rapid change, partly brought about by the, accelerated by the downturn, but not the result of the downturn. I think the last 2 years have been very significant in terms of change in the profession. The main thing that's happening, though, is a new kind of competition through information technology. Internally, I had a bunch of slides that show a wide variety of tools that we've built, and I see Steve Harmon from my department who's a lawyer who's recovered and is now in charge of my information technology group in the legal department and is really driving a lot of the creation of tools that radically simplify the way we do legal services internally, give my internal clients access to the information they need when they need it. So I do a lot of that internally, and I'm always astounded by the fact that this is, and I shouldn't say astounded, that's just reflecting my own narrowness, the degree to which companies everywhere are doing this. And there are really wonderful implementations in a lot of corporate legal departments around the country and the world that don't get a lot of attention but are transforming the way legal work gets done in those operations. A year ago, I spent 2 months working on the presidential transition, and my job was to identify ways that general counsel and the government could make their work more efficient. And you know, a lot of people heard about that assignment and would say to me, well, that must have been awful. Nobody's doing anything. It's the government. And nothing could be further from the truth. The Navy, there's a really astounding implementation called the General Counsel Desktop, General Counsel Online, that is much more sophisticated than anything I've ever built at Cisco. In the Interior Department, they basically used Microsoft SharePoint as a platform for 6 different types of services to use internally. And all over the government, there were individuals who saw opportunities to do things on one-off tool bases that made things more efficient. On the other hand, there were a lot of places I looked that it might as well have been, you know, quill pen and candlelight. You couldn't get access to documents other people had written. If someone in Health and Human Services had written a memo about interstate shipment of guinea pigs last year, and you had to write something about interstate shipment of snakes, you couldn't find it unless you knew the person who wrote it. There was no online repository for anything that got done in the General Counsel's office. And if you did find the person who wrote it, but they'd retired and everything had been sent to archives, you'd never be able to find it at all. At the SEC, Giovanni Prezioso, who had been Bush-era general counsel, told me that internal advisory opinions were unfindable because there was no repository. He couldn't get any budget to do it. And he made a determination after dealing with FOIA request after FOIA request that those should be public. So he required that they all be published. And he said, so I finally had an online repository where my lawyers could go to find the documents that had been written elsewhere in the department on particular subjects, easily searchable. Does anyone know the name of that repository? Google. Google was the right answer. So that's how the SEC solved the problem. But this is happening very, very quickly. What's happened in the last couple, in legal departments, even in the government, what's happening elsewhere is law firms starting to figure out how to take advantage of these opportunities. And let me give you two examples. One is something we've done with Aric. Is anyone from Aric here? No, if they were, I'd say thank you. Has worked with us to develop a global corporate secretarial tool. Like a lot of big companies, we have subsidiaries all over the world. We have more than 300 companies in the Cisco corporate family. We have to have annual filings in every single country where we operate. Tracking those is very hard. We had put it all online, scanned it in. I had internal people working on it. What Aric's done is now gone out and agreed to take that whole project on for us for 80% of what we've paid the last 3 years to do it. They hired the local counsel. They were ideal for it because they don't have a global network of offices, so they had to go negotiate with firms to put a network together. They use a lot of the firms we did previously, but not all. And the upshot is they've driven the cost down, and they've also agreed that every single year for the next 5 years, my cost needs to go down further. And the two comments that they made to me after getting the system up and running is, first, you know, this made us much more efficient to be operating on a fixed cost. Well, okay, glad you get that. That's good. And second, boy, it really makes us put pressure on the other firms to lower their costs every year to get more efficient themselves or to replace them with someone else, because we know that we have our money coming in from you going down every year. And that was a very good observation as well. I think it says something about that model of using vendors that they can go put pressure on, as opposed to a model where their profitability depends on finding ways for each of their local offices around the world to bill me $500 more next year than they did this year. So I think that Aric model is a good one. They now have 12 companies signed up to use the tool, not just us. And I'm glad we helped give them the idea. I'll help them continue to sell it, because I think it's a good idea, and hopefully other firms will start seeing it that way as well. The second transformation is a similar one, also related to changes in the payment structure, and that is in the litigation area. We're finding more and more firms taking the position that they will use contract attorneys to do a large part of the work in litigation, as opposed to their own associates. So now when we put out RFPs on litigation, looking for fixing our costs on litigation, step by step, you can't do it the whole way because there's too much uncertainty, but phase by phase, we are asking firms to provide a bid using attorneys other than firm associates, because the firm associates are too high. Well, partly because of the downturn, but I think as this becomes more prevalent, we're going to see a continuation of the trend this year, which is to drive down associate salaries, because there's no reason whatsoever that someone coming out of law school who really doesn't know how to do much at all is making more than 98% of the people who work hard in this country. And yet that's the model we got into, as productivity was defined by how many hours can you work, as opposed to what do you deliver to the client. So and information technology, the type of things that our sponsors today are offering to the world, are helping to drive that change the way the work gets done. So the new normal, my answer is driven by general counsel being measured the same way other parts of companies are being measured, and no longer being able to say, well, I have this black box that's called legal and you can't look inside. An information technology revolution that's making more tools available, and increasing competition between law firms who are driven to do work that's valued based on a negotiated price for doing a certain project of value to the client, as opposed to based solely on the input of people working a certain number of hours in order to get paid based on the hours they work. So with that, I'll turn it over and hope that's a few little observations from working out in the field.
So we asked the question, see if I can make this work, is what Cisco is doing an anomaly? Does Cisco represent an outlier, or they in fact represent the front end of a trend in the sense of the technology adoption lifecycle? So Bill Deckelman, who's the general counsel of CSC, which used to be Computer Sciences Corp, but I'm sure branding consultants got paid a lot of money, so now we only refer to it as CSC. Right. Is one of the top general counsels on the East Coast, so not just a West Coast phenomenon. So Bill and I kind of reached out and said, well, what is it going to look like when law normal and enterprise normal get together? And what we would suggest to you is it's going to look something like this. And this is all stuff that Mark has talked about. A greater degree of client intimacy, more predictable pricing, different attempts at the staffing model, sometimes outsourcing, sometimes unbundling, sometimes contract lawyers, more defined quality along the lines that Mark talked about, greater use of technology, not technology to displace lawyers, but technology to enhance lawyers, and an ongoing sense of process innovation, which I think is a commonplace for folks here. So we reached out to a couple of firms, a couple of OnRamp firms, and I think some might even not be on OnRamp, and said, well, does this make sense to you guys? And Bill can report on the results.
Thank you very much. And Mark, I definitely relate to all of your comments. But I have a specific job to do, and that's to run through these slides. And it's a little different for me. These are not my slides. These are from the firm. So I'm going to track my notes here just a little bit. But we have quite a few to show here, and I think of some interest. The first one here is an Australian firm, Mallisons, and they have built, you'll recognize this as a dashboard for an extranet. And obviously extranets have been around for a while, but what it's doing is giving detailed matter status to the clients. So it's real-time visibility. The clients are able to log on and take a look at matters they're interested in. I thought of note on this was the attempt, at least, to include forecasts for fees and estimates and an indication of where you are in the budget cycle, which is interesting. And I do like the dashboard format, so a pretty good presentation there. Another example here, I should have said at the beginning, if your firm is not one of these, talk to Paul Lippe. But no, actually, if you're not, there are a lot of great firms doing a lot of great things, and obviously we couldn't include all of them, but seriously, if you're not mentioned here, I'd say let Paul know and let him know what you're doing. This is an example from right here in Silicon Valley, the Cooley firm. And again, another example of real value add. This is an IP tracking system for the client's IP portfolio. And obviously just giving details on the status. So again, the client can check it online and see what's going on with particular patents, for example. It's another great example of a law firm making the investment in a knowledge management tool that really is useful to the client. Next, we'll look at Pillsbury, and they're in the world of e-discovery, which all of us are, but it's a world where costs are very volatile and can get out of control very quickly. So they've built a system and standardized their e-discovery process with their major clients, looking at it from an upstream standpoint, integrating with their clients' IT, and downstream by managing the deliverables and the pricing of the vendors. So again, a good value-add platform for the clients. And notice, what I noticed about this was it's scalable, but it's also reusable, very important for other litigation matters. We have a few slides sprinkled in here from General Counsel Roundtable, just to look at it more from a broader perspective as opposed to particular firms. But the purpose of this is looking at predictable pricing that Paul mentioned. As you can see, this is a scale from 2007 to 2009. Definitely a marked increase in law departments insisting and law firms agreeing to alternative fee structures. Aric was mentioned earlier. This is another example from them. They have a lower cost staffing center in West Virginia that they have leveraged, and this particular slide is focused on alternative staffing. So as you can see, and I think some other firms have done this as well, they've redesigned their traditional approach to legal staffing and the career tracks within the firm. So by doing this, they're able to lower their costs. They can dedicate lower cost lawyers to particular projects that perhaps they would not have even had in the door before. Again, going back to General Counsel Roundtable, this is just demonstrating that law departments are really focused on, and this has been going on for some time, but it's not letting up, but it's getting actually accelerating, looking at ways to take parts of services that many times traditionally law firms provided kind of behind the curtain, and law departments now are engaged in all kinds of offshoring, nearshoring, whatever you want to call it, to bring those services out, to outsource those to more efficient providers. The next firm we'll look at is Kano Gates, another global firm. This is an example of where they were involved with the merger of two financial services clients, and what's notable about this is it seems to demonstrate they were probably providing or engaged in all of these aspects of the new normal we're talking about here, but we wanted to highlight this because, as you see, they did agree on consistent service protocols, as they call it here, with the client. So in the realm of defined quality, this is an example of where they're doing that. Again, going back to General Counsel Roundtable, as Mark described, metrics have really come into play significantly. They have been for quite some time, but I would say in the last 2 years, as a result of the economic situation, it's become even more critical, a lot more focus from the CFO's office on what the legal department is doing. Next one we'll look at is Latham Watkins, and this is from their London office. Now we're getting into the contracts area, which is closely related to legal. This is a product they call Capture and Captivate, and it allows clients to self-generate contracts, and then it tracks the relevant information afterwards. So here you see a law firm really getting into the contract management space, which for large companies, global companies, this is becoming more and more of a headache and an issue that has to be dealt with. So pretty creative. Again, here in the Valley, Wilson Sonsini, in terms of process innovation, they've created this automated user-driven site here for forms for startups and venture-backed startups, and allowing the entrepreneur to get on and create his own documents to expedite the process. So they're also providing information that the entrepreneurs would find of interest. And so they're getting the relationship early with the client through a self-automated way here. Another example of process innovation, Fenwick and West, and here we have Cisco. So Mark probably should be talking to this one, but I'll show it here. Just a focus on the diligence process and M&A transactions, and I guess more importantly, the integration after the transaction, and using share rooms to consolidate documents and data post-closing. So another great example. Then we have Womble and Carlisle. This is, I'm sure a lot of people recognize the Heartland Payment Systems situation that occurred a year or two ago, largest data security breach in history, so it naturally fostered a lot of investigations and litigation, and obviously, as they say here, a daunting document production situation. So what they were engaged in here was a project management solution to bring all this together, and notably bringing in Six Sigma trained MBAs to provide the quality control. And if anything, I would say, just to wrap up, because I believe that's the last slide, Paul, in this group, is that I think that's what we're seeing more and more of, is the law firms more focused on bringing in in a non-traditional way, bringing in help from the business side to get this right, get innovation right as we go forward. So with that, I'll stop and then turn it over to you, Paul.
Thank you. So I think the question that gets asked, what's the new normal? Does Cisco to Silicon Valley represent the new normal or an outlier? I think what Bill has presented is obviously a lot of compelling evidence that there are many, many examples of this. So Aric Press is I don't know what, you're the dean of all things legal and a professional interviewer, so I hesitate to ask him any questions. So Aric is going to speak to kind of, we'll call the more traditional view of law of how this may happen, and is this in fact happening or not, and how will we know it?
Thank you, Paul. Just to be clear, I'm the only one of these guys up here who doesn't talk for a living, so I beg your indulgence. And I didn't bring any slides, and I will be brief, so there's some time for question and answer. To answer the question, is there a new normal? Not yet. Will there be a new normal? I'm not sure. Will there be several new normals? I'm pretty sure that that's actually the direction in which the big law firms, mega law firms, or firms that hope to serve clients such as these are headed. Just very briefly, the history of the large law firms, which is the only community I know anything about, and I come from the outside. I do not defend their behavior. I am merely reporting it. Please. They built themselves up into mega size over the last decade or so with the hopes that they would all compete for high value, price insensitive work, and there's a certain amount of that around. They really do define productivity not by efficiency or task accomplished, but by how many hours. I mean, I had to do this job for 3 or 4 years before I really believed that was how it was defined. It really is. They got away with, for the longest time, doing some high-value work, but doing a fair amount of not high-value work, but not differentiating in the price. That seems to be coming to an end, some places, but not every place. There are lots of law firms that have figured this out, the notion that they have to be able to identify that which is repetitive or can be made repetitive and find more efficient ways of doing it. There are virtually every major law firm in America is experimenting with some form of alternative fee arrangement. A huge number of the major clients are doing the same. It's all on the margin with some notable exceptions. And by on the margins, I mean in single or low double digits percentages of actual legal spend. Will that continue to grow? Maybe. What happens when, well, none of us want to contemplate Eliot Spitzer calling us in the night, but what happens when Mr. Cuomo calls your principal in the night? Is your first call to John Kecker a discussion of how he can do it alternatively, or how is he going to save your guys bacon? I think we all know the answer to that. If there's going to be change, significant change in this marketplace, it's got to be driven by the customer. Let me just say that again. It's got to be driven by the client. There's a lot of law firms who are willing to do this work, but they're not going to do it unless their clients are responsive to them. And as I've gone around and I talked to a fair number of clients and I talked to a fair number of large law firm lawyers, what I'm told consistently by both sides is that the one thing that no general counsel, present company excluded, can stand the thought of is the thought that by agreeing to some alternative fee, he or she will end up paying $50 more than if he or she had just done it by the billable hour, which speaks to some underlying trust problem in that relationship, which is a far bigger problem, I suspect, than we have time to discuss on this panel. The one thing I would say to you, those of you who are clients, with all humility, is What do you care what they pay their associates? What do you care what they pay their partners? What you care about is, one, the quality of their work, and two, the price they're giving you. Don't get into the, sorry. If I may, it's not clear to me why you want to get into the argument of their cost structure. Let them manage that. Just as you've got enough trouble running your own businesses, you don't need to run Abel Baker and Charlie's as well. And if I keep talking, there'll be no time for questioning. So
let's open it up for questions. We actually have quite a few. Oh yeah, please.
Comment on, I think you touched on some things that are very, very relevant. Maybe this will stimulate some questions. First, absolutely right about it coming from the customers. We've had law firms bring interesting things to us. We've tried to use them, and it doesn't always work out so well. And I've seen law firms have invested in a lot in trying to develop innovative solutions without having a customer available. It is not field of dreams. If you build it, we will not necessarily come. Second, you're absolutely right. When I refer to about salaries, when I refer to associate salaries, it was more by way of observation that the salaries will come down as opposed to something that I necessarily care about as long as I'm paying the right amount. I think it's very important for clients to focus on law firm profitability, though, and make sure that our business partners feel that they're making money working for us, because it's a critical part of that relationship. By the same token, sometimes rates should be very, very high. And I've never objected to a $1,000 an hour rate if I think that the person's valuable. If it's a situation where I need to get someone's time, their time is extremely in demand, and there's no other way to get the work done than having that person engage, whatever the market will bear is fine with me. And fourth, you made a sort of funny comment at the beginning about the law firms wanted to compete for price-insensitive work. And it's sort of an interesting conundrum there of how you compete for price-insensitive work. I mean, I guess one way you do it is you take your clients to ball games and that kind of thing, and whoever gets the best events maybe will win the business. But I think what the general counsel is starting to do is figure out ways to bring a price discussion into that. And if you see in the middle of the night you need a certain person to help you, you're going to call that person. That's not the vast majority of the legal work, however.
right.
It's probably not the case that John Kecker's the only one you can call either, even in that scenario.
But you're not going to negotiate at that point.
Yeah,
either.
once you've called
You
John.
can call someone you need and you get them.
But
The one quick comment I'd make is the big difference I think that I'm seeing is today when you have the conversation with the law firms, the bigger firms, and you're talking about alternative billing and you're talking about innovation, you're no longer getting that kind of blank stare. It's more of, oh yes, we're hearing this from all of our clients. So as compared to just literally 2 years ago, the conversation is wholly different. And I think what's happened is you're seeing so much of the law firms now, and if there's one thing about law firms, they are competitive. They do look at their peers and what's going on there, and they see what they're doing for clients, and that's going to drive a lot of this innovation, I think, from the law firms.
So let's open it up for questions. A couple of ground rules. One, I think we started a little late because of the rain, and some people may stick around, and some people need to leave. So if you need to leave, head off, and we'll probably try to answer questions as long as it's lively. Two, there are microphones, so please do use the microphone. And please do identify yourself and kind of where you're coming from. And three, I will use the moderator's privilege and add to your introduction if I feel it's worthy, if I remember, if my eyesight can see. And are you the first question? Yes, sir.
I believe so.
Kick it off.
First in, best dressed. Jeff Richards, I'm with the Office of the CIO. We're an IT consulting firm. My question's for Mark. And you mentioned earlier Steve Harmon, who works as your legal department. My question is, what is your legal spend as a percentage of your total spend? And does Steve report to you, or does he report to your CIO, Rebecca Jacoby?
Great question. Steve reports to me, and his team, and Risa Schwartz is sitting with him, who used to be at Wilson Sonsini, drove a lot of their early innovation, and is a key part of our rolling this out as well. Their team is thought leadership. So a lot of the implementation is through Rebecca and through our IT organization, but the thought leadership is with me. My legal spend is about $160 million a year, about 55 of which is internal. The balance is outside and with law firms or with other vendors who are doing quasi-legal work for us. That's about 0.4% of our revenue. And my goal is to get that. It absolutely is, yeah. We're a client-funded model on the IT side, so in addition to paying for Steve and Risa and the work that their teams do, I also pay to the IT organization to fund the development of individual tools. And we have tools across the board, probably 50 different tools that we use for various types of activities along the lines that Bill highlighted, working with some of the law firms.
And to tie back to what Aric said earlier, one of Aric's publications, I don't remember which one, reported recently that Microsoft's legal spending was close to 2% of revenue versus Mark's 0.4%. So while the lawyer classic might posit that when you call John Kecker late at the night, you're price insensitive, I would suggest to you that in fact the data shows generally that the more people spend on legal, the more legal problems they have. Now, obviously, folks would argue, and that's probably the next panel, what's causation and what's correlation. But I don't think anybody can show data that shows more spending on legal actually results to fewer calls to John Kecker. And go to Bill Henderson from Indiana.
Yeah, Bill Henderson from Indiana. Fascinating panel. I can't believe the number of interesting examples that were put forward today. Very stimulating. But this is primarily to Bill and Mark, but I'd be interested in what Paul and Aric have to say. In terms of, say, I want to do business with you, and I want to go down some of these new trails with you. And Bill, you said that when you're talking to outside counsel about some of these ideas, you no longer get blank stares. Can you give me a breakdown between people who will engage in this conversation and the people that want to have this conversation? So that's part one. In part two, once they cut this cockamamie deal with CSC or Cisco, or what's viewed as it, how are they received? I don't think it's cockamamie, but how will it be received by the kind of the old guard back at the firm in terms of what kind of feedback loop are you getting in terms of internal resistance or embracing the new era?
Bill is a professor at the University of Indiana Law School. He's probably the leader in empiricism within the legal academia. So he's actually doing field work here, which perhaps might get too detailed for some folks in the audience. But if you can take that on, that would be great.
Yeah, well, we've been engaged for some time now, and you mentioned trust earlier. I think a lot of this requires some pretty deep discussion with the firms and really establishing relationships with a finite number of firms. You can't deal with every firm on this level. Because it does take time to develop that trust, and these arrangements do require the trust. But from what I'm seeing, I can't give you a percentage, but I'm seeing an overwhelming number of firms having the discussion, and this time actually having something to show. Now, how much of an investment is that, and how serious are they about it, and how much will they follow through? I don't know yet, and to the point earlier, we're kind of on the front end of a lot of this. We'll see. But I'm seeing it as kind of a prevalent approach out there from the firms. And, I've had meetings with very senior partners who, many of whom get it. They actually get it, but they will acknowledge that there is definite resistance back at the firm. So I think we're going to see a substantial amount of resistance along the way. And again, I think it's going to come back to this competition that starts to drive it. And I do agree that the last 2 years, the economic situation has really put a sharper edge on this for legal departments and general counsel. So we're driving a lot of it. We're adamant about it. We're going to drive it in the next year or two so that we're moving more and more to that model. And the firms that we're going to do business with are the ones that can bring us the value add. If we're going to use a large global law firm, and frankly, you're going to pay for that infrastructure, then I want the value add coming back from innovation.
I think that covers it.
This is really for...
Can you identify yourself?
Oh, yes, I certainly will. My name is Craig Jones. I'm a venture capitalist and an angel investor. It is for anybody on the panel because it's a broad question. I'm an investor in a company that uses technology to help settle litigation. It actually uses software to, in a double-blind fashion, to have, bid and offer and acceptance on a settlement of a claim. Happens to be a company called CyberSettle, based out of Connecticut. My question to you is more broad. How do you see technology actually changing the way we go about dispute resolution or any other aspect of the legal industry? When I've looked at legal IT deals over the years, it's basically been about more efficient push of information to lawyers. And you've educated me today that no, it's not just that, it's also pushing more efficient information to the client, which is great, and maybe even some self-serve. But what about the broader use of technology to actually shorten the length of litigation, to reduce the number of disputes, to all of the fundamental parts of legal disputes? What are you seeing out there that fundamentally could change the system? And it gets a little bit to your point that, does this compete with lawyers, what lawyers, do for a living? But what do you see out there that's more fundamental reform?
Do you want to do this?
Have you seen anything?
I mean, to the degree that there's much, it's more on the consumer end, I think, rather than at the corporate end. But that's just what I'm aware of.
Yeah, I have to say, I think it's, maybe we're just too far on the front end of all this, but it's much more around using the IT to automate these traditional processes, that lawyers use, and early case assessment and things like that. But the actual, intelligence tool that you're talking about, I haven't seen that.
Craig, I think it's a really good question. And I was at a dinner several years ago. I found myself sitting next to one of our great district court jurists here in Northern California, Judge Susie Ilston. And Judge Ilston looked at me during the dinner and she said, "Just tell me, has Cisco ever been sued meritoriously?" And my answer was, well, I'm sure there has been a case, but usually the complaint is so filled with falsehoods and bizarre allegations that it's impossible for me to tell. And I think the issue in dispute resolution, at least at the corporate level, there may be mass consumer issues where automated tools can help. But I think it's the litigation process itself that gives leverage to one party or another out of the inefficiencies in the process itself. So I often find parties on the other side very uninterested in efficiency because it's the very inefficiency of the process that provides leverage to try to extract value from me. And I think the solution is up to judges. And if I were doing something like that, I would be pitching it to judges and say, you don't like how big your docket is. You don't like all the crazy motions you're dealing with all the time. Here are some things that you can use to help screen this stuff out, keep the noise level down, so you get more efficient results in litigation. But the way I see it is the way the judges run the trials and the way the litigation process and the rules of procedure have unfolded that give that leverage to parties and make one party to a particular litigation very uninterested in finding efficient resolution.
Paul?
Yeah, my name is Paul Ward. I'm with Riley, Carlock, and Applewhite. We're one of the firms that's kind of focusing on providing unbundled legal services. Question I have is I had the opportunity 10 years ago to get involved, a little over 10 years ago, to get involved in the founding of law.com. And it was interesting, as Aric knows, to sit around the table and envision what was going to happen in 10 years. And some stuff we got really right. Sometimes we got some stuff we got really wrong. As we talk about being at the start of this curve, if we got time, Paul, I'd just like to hear a snippet from each. What's the thing in 10 years that you think, based on pain, based on what you're seeing, what's going to be the biggest change in the legal industry from your perspective?
That was going to be my closing question, so I'll let Aric answer that one, unless someone else wants to go first.
I suspect that we will see a lot of law firms where you already see them where they don't know each other, but where the staffing patterns are such that there are a lot of lawyers in Bangalore and some in Bangor and some on Broad Street, all serving a law firm that's based in, you pick it, Dallas. I think the internal hiring, recruiting, promotion, talent issues will be significantly different from the way they're done today.
I would say related to that, 10 years is a long time, but I do believe that by then the firms will be operating a lot differently. I think they'll be finally very integrated with the clients. I think knowledge management may finally be, to its fruition and actually be working. I think we can do that in 10 years, but I think that'll be the biggest change.
Yeah, I concur completely with what Aric and Bill have said. I will make one observation about this that may be near and dear to Professor Henderson's heart, and that is that when the law firm's ability to fund the education of associates at the expense of clients dissipates, which is what will happen in the model Aric describes, law schools are going to have to play a very different role. And I think some very creative thinking is going on by Larry Kramer here at Stanford, David Van Zandt at Northwestern, and others about what the law school should be doing in terms of clinical programs and others, so that people come out of law school with some practical skills and some broader knowledge that will be directly relevant to what they're doing when they enter the workforce. And we may see a trend. I certainly haven't seen it even nascently yet, although I've been reading more about it than I did 10 years ago, toward the sort of articled clerk system that exists in the UK versus the associate system that developed in this country.
I think Aric runs the top black tie dinner for lawyers. I've never been there, but I'm sure it's a grand affair, and they
You're
recognize.
always invited.
Thank you. I've got to call my old tuxedo rental place, but they recognize a kind of a lawyer lifetime achievement award. So 10 years from now, Aric will present the lifetime achievement award to Mark for leading this transformation, and there'll be a bunch of people in the back of the room snickering, saying, "Why would you get an award for that? That's so obvious. Everybody knew that was going to happen." So at the point at which it's happened, it will have been obvious, and the analogs in other industries will be obvious. For some people, it will never become obvious, and they'll succeed or not succeed, and some people will change. But when it's done, it'll have been obvious, and we'll all be bored with the subject. So this is not just a U.S. discussion, but I think we've got folks from around the world. So Aric?
Thank you, Paul. Aric Valgaeren with Herbert Smith, Stibbe, Gleis, Lutz. We are a global law firm. We have 2,200 lawyers primarily in Europe, in the Middle East and Africa. And of course, as a law firm, we also look at new challenges and new value that we can create by adopting technology in the way we work. I think what Aric mentioned about the impact competition has between the firms is probably what mainly drives us, because we also indeed tend to be very careful with the risk related to adopting new technologies in the relationships with our clients. I was very interested in the examples that were being shown of success stories, occasions or situations where it worked out well. In Europe, we've seen, especially in the area of legal outsourcing, some situations where it didn't work out well, and that has a major impact on the quality brand of a firm. And so I'll be teaching at Stanford tomorrow, but I'll be meeting with some clients and colleagues here in the Valley. And I'm interested also in finding out how do they assess the risk related to introducing and adopting some of these technologies. And are there models then that actually involve some risk sharing with the clients who are driving often the process, as I agree with Aric actually should be the case. So how do we go about risk, and risk in terms of, if it doesn't work out, also risk relating to the product or the service that you're being provided, and how is that being dealt with? But
are you focused primarily on pricing risk, or on some adverse event, or risk that the work doesn't get done, or all of the above?
Well, primarily the risk relating to the trial and error aspect of introducing a technology. I mean, a lot of companies have gone bust because of making the wrong choices. And of course, in Europe, we have the advantage that actually we still get invited by the clients to go to the ball game and not the other way around. So it does change a little bit the kind of pressure we're under. But we do consider the choices in the technologies. But the question is, how does a firm analyze or assess the risk? And do they have a discussion with their clients about it? And is there any sharing involved? So if you have any thoughts on that,
if I can, maybe ask Bill to sort of address, how does CSC have that conversation with your customers just by way of analog? And then how would you expect that to map to the law firms? Would that be fair?
Our clients, our IT services clients, oh my gosh, we have lots of those conversations, as you can imagine. And of course there's risk sharing. But I think the analog plays true here is that for a company that has multiple clients, you can spread that risk because they all have similar needs. They may not be identical, but same thing with law firms is they've got, as I said earlier, clients who are all asking the same questions. They may have slightly different ways of going about it, but the core platform, the technology, the investment in that can be spread among clients. So I'm not finding a lot of law firms who are overly concerned about that because they can spread the risk. And these are the larger firms, of course. So, but having said that, I'd be happy to have that conversation. The other risk I thought you were probably alluding to was just the security, the data risk, which probably, certainly is a big issue in Europe. You have to be careful about it internationally, but there again, I think that is well along on the way, and I'm sure Mark will speak to that too, but I think that's very controllable and predictable risk.
Anybody else want to respond? In the back?
Mike Stern from Cooley. This is more of a comment, Bill. It may be helpful for your field research. In 1996, Cooley was Cisco's outside trademark counsel, and Mark's illustrious predecessor, Dan Scheinman, asked us to develop the system that was on the slide. But we said no, they fired us. So it's now 2010. We have a system. That'll give you some way to extrapolate whether we've hit the tipping point and what the adoption curve is for law firms.
Yeah.
Brian Goodman, Resources Global. One of the things that has not been mentioned today, a lot of the conversation has been focused on law firms and how they're innovating and changing. We're also seeing a trend in the profession focusing on insourcing of lawyers, where there are tremendously talented professionals that have come from these large firms that have also been in-house that are looking for a different way of life. It's something that we specialize in, and love to speak to the Indiana guys, being an Indiana alum. And was curious on your perspective from each of you, what you're seeing of, again, these top attorneys that have been in the law firms, they've seen both sides of the equation that are now being insourced to these corporations.
We're definitely seeing some of that. And to your point, over the last 2 years when we had hiring needs, we were able to hire top quality talent because there was a lot out there. So that's great. But yes, we're seeing law firms in situations like that and doing some unique kinds of secondment and arrangements like that to address specific issues. So it works very well, I think, and now is a great time for that.
In the back? Or? Oh, yep.
Hi, this is Vaibhav Parikh from Reshaped Associates. I'm an Indian lawyer, basically headquartered in Mumbai and Bangalore, and we have an office here. We practice Indian law. What I've seen traditionally in the last several years is it's difficult to get law firm, in the boom time, it's difficult to get a law firm's time and commitment to work on a business and on a transaction, and you're really trying to focus to get their attention. In the downturn, we are seeing that law firms are trying to vie for work, and because of which there's a lot more flexibility in adopting alternative pricing, alternative hiring, technology, and so on and so forth, which is what we saw in new normal. Do you think the progress of new normal will slow down when the boom time comes again? And when lawyers are so busy, they are billing 3,000 hours, they say, look, I don't have time for the new normal. Let me go back to the old world where I was just billing by an hour. Or do you think this is here to stay?
Well, I think it's 3-1 for sure. I don't know if it's 4-0 on this one or not. Aric, why don't you answer?
I think it's here to stay where it's here to stay. It's not. Look, I sat at a dinner not so long ago in New York where on one side of me was a guy who couldn't wait to bill all his clients on a value basis. He defined value as upside, no downside. And the guy on the left of me who was absolutely sure that we were just in a supply and demand glitch, and that once that resolved, everything would go back to normal. Both of them had houses on Nantucket. I live in Brooklyn. I'm thinking, which one of us is the smart guy? So with all due humility, I think that for some, at each of the, lots of grand law firms are listed on the slides we saw, and they're experimenting. Whether they will experiment beyond the margin, we don't know. And when times get really good, if the customer doesn't continue to ask for change, they're only human, and they're only suntanned, but that's a different.
I got a little bit different perspective on this, and I think your comment was right on in terms of the change in staffing models and resourcing. There are many ways to get the job done now, so there may well be a time when it's harder to find resources, but there are also more ways to get the job done than there were before because of different staffing models, because of the number of people who aren't insourcing themselves necessarily, but have found ways to work from lower cost locations. I don't care what furniture and art people have in their offices. I never go to anybody's law office. They come to me, or we meet somewhere else. But even the firms in Palo Alto or San Francisco, there's no reason for me to go there. So you have a lot of people, very good people, finding ways to do sophisticated work through different staffing models than what the larger firms have used. So I think although pricing may go up as demand goes up, there will still be a change in the way the work gets done. And that was why I started my observations by talking about the role of technology in driving change in knowledge-based industries. People are finding new ways to get work done. There will be competition because of that. And although the overall costs will track the global economy and supply and demand, the fact that there are different ways to get the work done will transform the way legal work gets done. To me, this is not a zero-sum game about me saving money and the law firm making less money. I think there are ways to keep profitability at the same level by thinking creatively about how to do the work. And that's what the legal world has become exposed to that it wasn't before, which is the challenge of figuring out how to do things efficiently. So there will be plenty of ways to still own a house on Nantucket for lawyers. Nobody should be worried about that.
We've got one last question. Before we do, I'm going to see if I can even call on Marty Collins to help answer this question. So in 1947, the U.S. was 46% of global GDP, and we had dominant companies in every field. Today, we're in the mid-20s. You've got, obviously, the rise of China, the rise of India, a fundamental structural change in the competitive landscape for enterprises. You can either bet that that's the dominant force in the universe, and companies will have to respond to that, and lawyers will respond to that, which is obviously the bet that some of us are making. Or you can bet that lawyers will get to continue doing things they want because that's their experience set and that's their preference. Empirically, I don't know how you can make that second bet. Marty, I'll just give you a shout out here. Marty's the general counsel of Novellus. He just came back from a couple years in Singapore. Which is the bet that you'd make as to what the dominant force in the universe in the next 10 years is going to be?
Well, I think Aric's right about there's always going to be New York lawyers. I mean, Sullivan and Cromwell, John Keck are going to do fine. But I think in terms of lawyering, it's like the difference between China and the U.S. I mean, there's going to be a couple people that can keep the old model. I think it is going to change. You cannot pay associates these rates. Mark's absolutely right about schooling. It's what we all grew up with is not going to continue. You can spend some time in Asia and see that. You can read that. James Fallows has a nice piece about why it might not be that bad for the U.S. But I think also Aric's point is we've got a responsibility to drive that change. And I'm not sure all of us have fully, and I know that I haven't fully acquitted that responsibility. But I'm now more fired up about it, so I'll get right back on it.
Last question from the back, and then I'm sure folks will stick around for a little bit.
My name's Martin Silver. I'm a CFO of a $40 million company. It's venture-backed. One of the things that I noticed a year ago when I was asking my employees to take a 5% salary increase, I got a letter from our law firm that their rates were going up. And I wouldn't really mind that if I felt like I was getting improved productivity. But what I was wondering is, some of this cost that they're incurring, what's driving that? Are they're bringing in some of these tools? I wouldn't really mind if the rates went up if I got more productivity. Are you really seeing that?
No, I don't think it's the innovation. It's the investment in innovation that's driven up cost by any means.
Sorry, go ahead. I was going to say, with rates, you're still letting the firm measure the input that they're giving you by the value of how many hours someone spends. So I would say, go talk to my friends at Fenwick and West, who for years now have been doing all of our corporate and M&A work on a fixed fee basis, and that's meant that every year they come to me and say, gee, we thought of a better way to do this and bring the costs down, and let's share those savings. And I don't know how they account for the time internally of people. I don't have a clue what anybody's rate is at Fenwick. I mean, I pay them millions of dollars every year. All I know is that every year my company's growing and my costs are going down. And that's a good thing. And if people are making more money at the firm because we're sharing the savings and they're thinking of better ways to do it, I think that's a wonderful thing.
So I think that's it for questions. I'm sure folks will stick around a little bit. Thank you all very much for coming. Thank you very much to the Churchill Club. Thank you, great panelists. I guess this video will be available on YouTube at some point, and thanks for coming in a rainy morning.
Just want to thank you again. Thank our sponsors, Applied Discovery, CT Timemetrics, and Vintage Filings. We have, as a small token of our appreciation, a stylish Churchill Club t-shirt. Please wear it in good health. Thank you again, and thank you all for coming.